So, understanding the annual review process. Good morning, everybody. My name is Beverly Watkins. I've been practicing in education law for about 25 years. And this seminar, I hope, will provide those parents that have an EHCP with a better understanding of the annual review process. If you live in Wales, the annual review process is slightly different because you have statements, and come September, the system in Wales will change again, and we will put on some specific seminars to deal with the Welsh changes later in the year. At the moment, there's very little information about the changes. We know a bit, but not enough. But hopefully more information will be provided, and so we'll put on a seminar later. So what we're going to cover is exploring the annual review process, which is very important for those that have an EHCP. And in my experience, local authorities frequently do not follow and do not comply with their statutory obligations. And where local authorities do not comply with the legal timeframes, do not comply with their statutory obligations, often you do not have a right of appeal to a special needs tribunal in respect of the failure of the local authority to comply with those particular statutory obligations. Your remedy is by way of judicial review proceedings. And in fact, listening in with this seminar is Keith Lomax, who practices, specialises in judicial review proceedings. So I will now start. So what is the annual review process? The annual review is the statutory process, and it is a statutory process. It's not, oh, should we have a little look at this? We ought to. It is a statutory process looking at the needs and provisions specified in the HCP and deciding whether these needs, the provision set out in B, sorry, the needs set out in B and the provision set out in F need to change. If you attend an annual review, my view is that you should go through section B line by line. So read it out, read out section B. Does it still apply? Does it need changing? Then move to section F. In the light of the changes you've made to B, do you need changes to F? If in B at the annual review meeting, your child or young person, let's call them Jemima Puddleduck, has now started, for example, it might say in their EHCP that they're non-verbal, but they might now have, for example, 20 words. So in F, it might be that they need more direct speech and language therapy from qualified and experienced speech and language therapists in order to encourage their speech. So you do need to look at every line. It's not just a, you know, hi everybody, great to meet you, haven't seen you since last year, sort of meeting. It needs to go through section B and section F line by line. The first review of the HCP plan must be held within 12 months of the HCP being finalised, and any subsequent reviews must take place 12 months after that. Now, whose obligation is it to arrange the annual review? Usually the school will arrange the annual review and then invite the local authority. It's usually the school that will set up the meeting, because the meeting is usually in the school. So there's no point having an annual review when you, for example, on the morning of the school concert. So the school usually fix the date. Some schools will fix the date a year in advance. If you don't have a date for your annual review, chase the school, chase the local authority. So once you've got your date for annual review, the local authority must consult with you as a parent and with the school or institution and take account, if there is one. Of course, some young people may have education otherwise at home, and take account of everyone's views, wishes and feelings. So the annual review must discuss, as I've already said, section B and F in particular. And in some cases, you will also be discussing section I if either the parents feel that there should be a change of place, or if the school feel they can no longer meet the needs as set out in section B, or make the provision in section F. So information must be gathered from you and from professionals about the EHC plan and then circulated 2 weeks before the meeting. Now, if I was, I can say without any hesitation that I have never come across almost, I can't think of one in 20 odd years where a school local authority managed to circulate all of the reports 2 weeks prior to the meeting. And what it means, what happens in practice, this is what should happen, and maybe you as a parent should be gently reminding your school that you would like the reports 2 weeks prior to the meeting. What generally happens is that parents attend an annual review, and there on the table in front of them is the updated speech and language report, updated report from class teacher, updated report from OT, and any other report. The parents, of course, will have provided a short report from them saying what they feel needs to change. And what I would advise parents to do a month or so before your annual review, sit down, look at the EHCP and think about what changes you would like to B and F, and put that in a document and mark it parental contribution to annual review. Now, because I'm already been very critical about schools and professionals not providing reports in advance, please do try and send your report to the school at least 2 weeks before. If you are faced with a pile of reports prior to an annual review, do ask for half an hour or so in order to read the reports, because in my view, it's really, really unfair on parents to expect them at an annual review to absorb, take in what these reports are saying and what are the recommendations, because what you want to know from these speech and language, OT reports, class teacher reports is your child still making progress? Are they meeting the targets that has been previously discussed? Look at outcomes in the HCP. Are any of those being met in respect of learning, in respect of speech and language or OT? It is the current EHC process, in my view, can be quite unfair on parents when you're faced with this huge amount of reports at the last minute. So after the meeting, the school has the duty to provide a report of what was happened, and they circulate this to everyone who's attended, and then that goes off to the local authority who review the contribution. Now, at an annual review, a local authority does not have to attend. Local authorities attend some annual reviews, but not all. They tend to attend annual reviews where they are aware that parents might be seeking an alternative placement that might cost them a bob or two, or where there is a transition. So if it's transition from primary to secondary, or it's transition from 16 to post-16, or from 19 to anything post-16, if it's a change when they're 19, they might well attend. They might attend in other cases, but they don't always attend. They don't have to attend. It's that they're invited to the meeting, but they don't have to attend. But they're then sent all the reports, they look at them, and they make the decision about whether to amend the HCP. So the local authority must notify you of their decision within 4 weeks of the meeting as to what they're going to do. So please be aware of the annual review timelines, because local authorities will not, local authorities often do not comply. What you should do is have a note of these time limits and be chasing the local authority. Unfortunately, while I'm suggesting to you to put in your diaries these dates, the local authority may not do. And it does often come down to parents to chase the local authority to comply with these time limits. So 4 weeks from the date of the annual review, the local authority must issue a decision notice stating whether it will cease to maintain, i.e. it will cease the EHCP or maintain the HCP or amend the HCP. Well, there's not many cases where following an annual review, a local authority will cease to maintain the EHCP. Following an annual review, you would expect there to be some changes to an EHCP. Where you have a case where a child or young person has had the same EHCP for 8 years, something is wrong. Usually you would expect something to have changed because you would expect that child or young person to have made some progress. Or the local authority will amend the HCP. 8 weeks from the date of the decision letter, if the local authority agrees to amend, the local authority must issue a proposed amended EHCP. This is the statutory timescale, and anything over this is considered undue delay in accordance with the SEN Code of Practice. Now, I'm going to pause there because in many cases, local authorities throughout the country do not comply with this timescale. We have had local authorities not issuing decision letters for anything up to 2 years after an annual review. And this is clearly not what should be happening. What is your remedy? Well, your remedy in this case is judicial review if they do not comply with the timescales and they're taking too long. Many local authorities are taking months and months and months to issue an amended EHCP following an annual review. And what this means is that during that period, children and young people are often not receiving the provision that they should be receiving because it's not set out in section F of their EHCP in the way it should be. In fact, Keith can maybe talk at the end. We have actually, or Keith, who is part of the firm, has a case at the Court of Appeal, which is going to be later in the month, which is very much about challenging local authorities to issue amended EHCPs following annual review because it can cause such harm to children and young people. So watch this space on the Court of Appeal, but do be alert to chasing local authorities if they don't comply. So once you've got your amended EHCP, you then have 15 days to review and respond to the proposed amended EHCP. So there are circumstances where an annual review must be held, and that is really transition. So if your child or young person is transferring to another school, generally, if you have the 3-tier school system, so lower, middle, upper, if the child is transferring from lower to middle or middle to upper, or primary to secondary, then you should have an amended EHCP naming what school or provision is to be made in section I by the 15th of February. So on Valentine's Day, when you're all having a glass of bubbly and a chocolate, remember, if you have a child with a transition, remember the next day is when you should receive your amended EHCP from the local authority. And I'll pause there again because a number of local authorities are not issuing the amended EHCP on or before the 15th of February. They're delaying significantly. And if the local authority delay issuing the amended EHCP, say to June or July, which they do in a lot of cases, that means that parent does not have the right to appeal to a special needs tribunal until that amended EHCP has been issued. And that can mean that that child or young person does not is not in education in September because the tribunal will not have made the decision prior to then. So it is important if you have a transition child or young person, make sure that you are knocking on the local authority's door on the 15th of February if you haven't received your amended EHCP. 31st of March is the key date for post-16s. So when you have an annual review, the local authority should consult the child's parents, and take account of their views, wishes and feelings, consider the child or young person's progress towards achieving the outcomes specified in the HC plan and whether these outcomes remain appropriate, and consult the school or other institution attended. So those are the key ones. So where a review of the EHCP is held and that young person attends school, the local authority can require the head teacher or principal of the school to arrange and hold that meeting without attendance. I've already said from the local authority. So the following person should always also be invited: child's parents. If it's early years, then it should be somebody from that setting. If it's a nursery, the local authority, usually SEN department, healthcare professional if they're involved, and any other person really that's involved. And you should have 2 weeks notice of any meeting. So I've already mentioned that that the school needs to prepare a report, and that the local authority should consider all of the reports prepared for the annual review. So I'm not going to pause on these slides. This presentation will be put on our Facebook page and YouTube channel, and you can pause on these slides because this is the detail which I've already gone into about the regulations. So if a child does not attend school, the annual review process is exactly the same as whereas a child does attend school, follows the same procedure, but you're not going to have a head teacher or anyone from the school writing a report, obviously. But anybody involved in making provision for that child or young person should write a report. So if there's a music therapist, a rebound therapist, physiotherapist, occupational therapist, speech and language therapist, any of those should be writing reports. So it's pretty much the same. So where the local authority is considering amending an EHCP following an annual review, it needs to send you a copy of the EHCP together with the notice specifying the proposed amendments, together with copies of any evidence which supports those amendments, provide you with notice of your right to request the local authority to secure that a particular school is or other institution is named in the plan, and give you 15 days to make representations. So where they are making amendments, they need you to finalise the EHCP within 8 weeks of sending you a copy of the EHCP, which it should have done 4 weeks after the annual review. So occasionally it might be said, particularly if you're having an annual review where the child's needs have changed significantly, you may request a reassessment by certain experts. So it might be that it's felt that perhaps the child or young person is either making very good progress or not making sufficient progress. You can request a reassessment by an educational psychologist or speech and language therapist or whatever, or physiotherapist, whichever expert you feel would provide useful information to the EHC process, given the progress or lack of progress that a child or young person has made. So when you receive the response from local authority, you should be provided with the current plan, proposed amendments and evidence supporting them. If you're unhappy, as somebody said, you have 15 days to respond. Once the final EHCP has been received, you will be notified, and that gives you a right of appeal. And the right of appeal is important. If you go back a few years, following an annual review, if you wanted amendments and the local authority refused to make any, you did not have the right of appeal. Now, if you seek amendments to the HCP and the local authority refuse, that gives you the right of appeal to a special education needs and disability tribunal. If the local authority makes amendments and you don't agree with them, that gives you the right of appeal to a special needs tribunal as well. So you can appeal in respect of section B, that it doesn't identify the needs of your child or young person, or in section F, that you're not happy with the provision, or section I, the proposed placement which has been suggested by the local authority. So look at the reports that have been provided to the annual review, and look and see if the local authority have fully taken those reports into account when amending the HCP. Take a look at our section F presentation, which is going to be detailed about what should be in section F, that it needs to be specified, quantified. Basically, anything in section F should leave no doubt as to what is being provided. It must, most EHCPs, in my view, that I see, are unlawful because section F is not specified, not quantified, and does leave doubt as to what the heck the local authority are meant to be providing. So where the code of practice says for a child under 5, that should be reviewed every 3 to 6 months. Very rare for local authority to do it. If you have a child under 5 and you feel an annual it would be helpful to have an annual review after 3 to 6 months, then do request this. What about if a child transfers to a new local authority? This can be problematic. If a child transfers to a new local authority, the old local authority must transfer the HCP to the new authority. The old authority must transfer the HCP on the day of the move, unless the old authority has not been provided within 15 working days notice of the move. The old local authority must transfer the HCP plan within 15 days, beginning with the day on which it became aware. If you're planning to move local authorities, definitely plan ahead, definitely let your new local authority you're coming, definitely send them a copy of the EHC plan as is. New local authority will review the plan before one of the deadlines, whichever is the later, within 12 months of the plan being made or being previously reviewed by the local authority, or within 3 months of the plan being transferred. It can be very difficult if you are moving house to secure promptly provision in an EHC plan from a new local authority. And this can be vital to a child or young person with special educational needs. So we've already mentioned that the review must be completed by the 15th of February in the calendar year of the transfer, if it's a key transfer, so from nursery, early years provided to school, infant to junior school, if they are separate, primary school or lower school to middle school, primary to secondary, and middle to upper. Post 16 is March 31st, and we've already mentioned that. Reassessment, you don't necessarily need a full reassessment for each annual review, but it depends on the circumstances. So if they if you've requested a reassessment, then the local authority should notify the child's parents of its decision as to whether or not it will undertake a reassessment within 15 calendar days of receiving the request to reassess. If the local authority decides not to reassess, it must notify the child's parent of their right to appeal that decision and the time limit for doing so, and the requirement for them to consider mediation should they wish to appeal. So the process for reassessment is pretty much the same as for the first assessment when you first got your EHCP. The more recent advice from professionals is likely to be the better. A report that is within the last 6 months or the last year is likely to be much more beneficial, much more relevant than a report that's a couple of years old. So for any parents looking at this, look at your EHCP, look at your K documents. Your K, the K part of the HCP sets out the documents and reports that contributed to the drafting of the HCP. See if there are any out of date and see whether you need any up-to-date reports. So if the local authority decides not to make any changes to an EHCP following an annual review, you can appeal. If they decide to amend, you can appeal once you've been sent the final amended EHCP. Now, the tribunal must receive your appeal within 2 months minus a day. So today is the 4th of February, she says, quickly glancing. So today is the 4th of February. If you received an EHCP plan today, any appeal needs to be lodged by the 3rd of April. In some cases, you might well be wanting to appeal as soon as you get that EHCP to get in the queue for appeals, because at the moment there are significant, there are quite a lot of delays with the tribunal process, in the sense that if you lodged an appeal today, you probably would not get a hearing date until June or July. And of course, if you're a transition, if your child or young person is transitioning to a new education setting, September 21, you want your appeal before September. In the past, where we've had transition cases and the young person's received their EHCP, let's say post 16 on March the 31st, they've lodged an appeal on April the 2nd, they still haven't got an appeal date until the middle of September, sometimes later. So often appealing promptly can be the best course of action. So an annual review should still take place regardless of any appeal currently taking place. And an annual review may help resolve some of the issues regarding the appeal. Although if you're just about to have a tribunal hearing, I'm not sure how useful an annual review can be, because in essence, the tribunal will review your EHCP. So what is judicial review and how can you use it in the annual review process? Judicial review is the process of challenging in court the lawfulness of decisions, actions, or failures to act by a public body. So it's about getting remedies from the court where the council is acting unlawfully. I've already mentioned several obligations on the local authority, such as to issue an amended EHCP or issue a notice saying they don't intend to amend following an annual review. And there's timeframes there. And if local authorities delay, they're failing in their statutory obligation. In addition, the local authority has the obligation to ensure that there is an annual review held. And if they fail to do that, then the remedy is annual review rather than appeal to a tribunal. If you do have an option of appealing, for example, you do not agree with the amended EHCP that has been provided, then that is your remedy rather than judicial review. So judicial review, usually a very detailed pre-action protocol letter is needed before making an application to court. And to be honest, in the majority of cases, by far, sending a pre-action letter to a local authority often brings about the result that you want. And one letter can often get the result that you're seeking. So if you send a pre-action protocol letter, for example, saying you haven't had, it's now 6 months after the annual review, and you haven't had notification that they're maintaining the same EHCP, or they are intending to amend it, usually sending a letter for action will result in them issuing the notice and amended EHCP within 14 days. Don't delay with judicial review. There's procedure requires you to act very promptly. Legal aid may be available for court proceedings if the local authority don't comply. So there we have a quick canter through annual annual review process, which is important if your child or young person has an EHCP. Can we now turn to questions to do with the EHC process?
Okay, so the first question is, do updated reports have to be provided by all professionals who had involvement with the EHC plan being written? The child's review is due next month. No other professional input in the last year. COVID given as a reason.
Yes, I guess with COVID there are going to be. It depends. That clearly COVID has affected all sorts of things to do with education as well as special needs. If there is an annual review, if those professionals who wrote reports for the initial EHCP have not been involved because of COVID, then it may be that they can't that there is no updating report they can provide. I guess, for example, well, my view would be if your child or young person has direct speech and language therapy in the EHCP, but they've not received any direct speech and language therapy during the last year because of COVID, then I'm not sure that they can provide any updating report, and you wouldn't want the provision changed. But if they have provided some, but not all, then maybe they could do a short report about what they have done. But what the updating reports should really come from those that have been involved in the child within the last year, not necessarily those involved in drafting reports for the initial EHCP. It should be those involved in the last year. And if due to the pandemic, there hasn't really been any involvement by those experts, then it may be I can't see that they can write anything that's going to be very useful. So that may be justification for them not writing a report. But I would still expect a report. The parents can write something saying, well, they feel that during how the pandemic has affected their child, and perhaps saying that they need some more input from speech and language or occupational therapy or whatever might assist, because it's been a difficult year for a lot of children. So the parents' report can be helpful, and also the class teacher, but it depends whether the child or young person has been actually in school very much, or the lessons have been remote. So I hope that's helpful. It really report, you don't have to have updating reports from, so the bottom line is you don't need updating reports from every expert who was involved and contributed to the initial EHCP, but you do want updating reports from anybody who's been involved in the past 12 months. If there is anybody that if you think that because of the pandemic, there has been a regression in some aspects, maybe sensory needs, and it may be you might say, well, actually, I want an up-to-date assessment from an occupational therapist prior to the annual review. So hopefully that's helpful. Next question.
Well, this isn't a question, but I'm now just going to hand over briefly and quickly to Keith Lomax, who just wants to go back and just reconfirm to you all a couple of things regarding the way in which the timeline works.
Okay, thank you, Keith.
Yes, this states that the decision notice must be given 4 weeks after the annual review. The third section says 8 weeks from the date of the decision letter, the local authority must issue a proposed amended EHCP. In fact, it's 8 weeks they must issue a final amended EHCP, not a proposed one. The local authority ought to send out the proposed amended plan 4 weeks after the annual review. Now, once they've sent out the proposed plan, they then have 8 weeks within to finalize it, and parents have 15 days to respond. So and there's an issue about that, because local authorities are interpreting the regulations differently from the way that we interpret them. They say that they'll send you a notice 4 weeks after the annual review saying whether they will amend it or not. They can then send you the proposed amended plan sometime later on. And then it's 8 weeks from when they send it to you until they make it finalized. That gives you a gap with no time control at all between telling you they're going to amend it and actually sending you the proposed plan. And we say that is unlawful. And that's the issue that is before the Court of Appeal on the 23rd of February. We say it makes no sense in that all the provisions for EHCPs, when you initially ask for one through to getting one through and the amendments and so on, have time limits. And it would be ridiculous to have a lack of any provision for timescale from an annual review to actually amending the plan and giving parents the opportunity to go to tribunal. And it appears to be a bit of messy drafting, but any sensible interpretation means that you should have a final amended EHCP 12 weeks after the annual review, and then you can go to the tribunal if you disagree with it. So I just wanted to clarify that point.
Oh, that's very helpful, Keith. And we'll watch that space with regards to the Court of Appeal case, which could have real benefits to all parents of children or young people with an EHCP.
Okay, so moving back on to questions, the next question is, should transitions to new phase, i.e. post-16, still have to take place during a tribunal? So the local authority did not actually carry out an annual review in 2020, and the young person was due to start in September 2020, and the LA stated that it was due to being in a tribunal. So this is the fact that if people have tribunals going ahead for placement issues and against the final EHC plan, what happens to the annual review that has to take place whilst the appeal is going ahead? Well,
it's one of those grey areas, really, because there ought to have been an annual review, and it would have been helpful to have an annual review, but the tribunal is like, the hearing itself is like an annual review, because the tribunal will be looking at all of the reports and will make decisions about B&F. Having an annual review may have helped you to come to some agreement with the local authority in respect of some parts of B&F, but the tribunal itself is, if you like an annual review, in the sense that it is carrying out the annual review process in detail, and looking at all of the up-to-date reports that have been provided by the local authority and the parents. So it depends on the circumstances of the case, would be my answer. And having pushing the local authority for an annual review might have helped reach agreement on some parts, but if it depends what's in dispute. What they must do is issue, if it was just go, when was the young person transitioning?
So it is, so they should have, the young person should have started in September 2020. And they didn't have an annual review in 2020. And the local authority won't make any additional decisions because there's an outstanding tribunal.
Right, they probably won't do anything now because there is an outstanding tribunal. But the annual review, given your young person was transitioning September 20, should have been really the end of 2019, because if your young person is transitioning, let's say September 20, the annual review needs to take place before Christmas, because they have to issue the amended EHCP by March 31st if it's post 16. If you've got a young person transitioning this year, so September 21, and you haven't had the annual review, at the end of this presentation, go and contact the school, college, local authority and say you need the annual review urgently, because the local authority must issue the amended EHCP if it's a transition to secondary by 15th of Feb, and if it's a transition post 16, then it's by March the 31st. You need that, and so generally annual reviews should be brought forward. So if they were transitioning September 20, I would not have necessarily expected an annual review in 2020. I would have expected it at the end of 2019 so that amendments could be considered, placement considered, and local authority issues the amended EHCP by either February the 15th or March the 31st.
Okay, the next question is one that we have happened quite a lot, and it's been asked quite a lot this week, is can a parent or young person write their own pre-action letter?
The answer is yes, but sadly the local authority, the pre-action letter for judicial review has to be is very much a legal letter. It has a legal format. It needs to be prescribed to a certain way, and you need to make reference to the legal provision that the local authority is breaching. So if the local authority is not complying with a legal obligation, then you need to set out the law very clearly. So I think that, to be honest, it can be quite a difficult thing for someone who is not a lawyer to draft, but if you are able to do that and you have some legal training, then yes, you can send that. It's not right. I'm not saying this is right, but often legal departments, because a properly formatted, properly argued letter before action for judicial review proceedings sent to the legal department by a lawyer is much more likely to be successful than one sent by a parent. I'm not saying that's right or justified. I'm just saying that it may be that the local authority just takes more action then. But there is no reason why any parent can't send a letter before action if they have some legal knowledge and feel able to do that.
Okay, so the next question is, can you force the local authority, and if so, how, to provide assessments they refused at the initial EHCP process generally? Also, in particular, well, just deal with that question and then I'll deal with the second
Okay,
part.
say that one again.
So can you force the local authority, and if so, how to provide assessments they refused at the initial EHCP process? So for instance, say the local authority refused as part of an EHC needs assessment to obtain a SALT report. Can you force the local authority to obtain one?
Well, that's an interesting question. I would say that if the child or young person has speech and language difficulties, then you should be able to argue that the local authority should carry out a speech and language assessment. I think, again, that might come down to judicial review, because the local authority are acting unreasonably in not carrying out that assessment. If it's clear this child or young person has significant speech and language needs or difficulties, then a proper assessment seems to me a reasonable request. And if the local authority refuse, they are being unreasonable. So again, that may be a judicial review challenge. It is, of course, always open, and I know that this may not be possible, but it is open to parents to instruct independent speech and language therapists. But that is obviously going to cost the parent money. It's quite wrong, but that you will not get that refunded. So if you have an independent, and the reality is that sadly an independent speech and language therapy report, or indeed independent OT report, can be of great benefit to parents, because it's likely to carry out, it will be much more thorough, it will carry out proper assessments, it will give you a good baseline, and it's likely to provide much more detailed recommendations about provision in F, So if you can afford an independent report, that can be helpful. If you do that and your independent speech and language therapist does provide a report with a lot of detailed provision, as night follows day, the local authority will then carry out an assessment, which will be on 2 pages of A4 at best quite often, and will have next to no provision in it. So it can be of help to obtain your own reports.
Okay, the second part of the question is that it is more in relation to health reports. And if there is a specific, for instance, gut issue in the child, but the CCG don't take it seriously, obviously private assessments are therefore going to be very, very expensive. Can you use any method to enforce the CCG to assess for a particular issue?
Oh, that's a very interesting one. I think that might be Keith. Is that judicial review again if they're being unreasonable?
Yes, I would say it's always judicial review when any public body is acting unreasonably. Any public body, CCG, local authority, government, whatever, has to make decisions objectively and properly informed. And if they're not informing themselves with the necessary evidence, then they can't make rational, reasonable decisions. And it is definitely challengeable under public law principles which apply to all public bodies.
Okay.
And am I correct, Keith, that legal aid may be available in the name of the child?
Yes, once you get to issuing judicial review proceedings, legal aid is available for the child because it's the child's claim. There's difficulties with the legal aid system assessing financially the resources at a pre-action stage. There's a difference between the pre-action stage and actually issuing proceedings. Certainly with issuing court proceedings, you can get legal aid on the basis of the child, and generally that means that they have no financial resources. For pre-action work, generally, it's based on parental income and capital, which presents more problems and has to be assessed case by case, of course.
So Keith, we had 2 questions that kind of covered that. So I think you've answered the one where about can legal aid be in the child's name. Somebody has asked if we do take legal aid cases, obviously for judicial review. So it might just need a little bit more explaining on that. And then somebody else confirmed the answer you gave regarding obviously how is pre-action protocol letters funded on a legal aid basis, and can they be funded on a legal aid basis?
Taking the second part first, because it comes first in the time scale for judicial review. The pre-action stage, where you are sending a pre-action letter and having a response and advising on that, this can be provided on legal aid, and yes, we as a firm do that work on legal aid, where the whole family qualifies financially. That includes where if you own a house, basically if your house is worth over £200,000, then you will not qualify for legal aid. That excludes an awful lot of people. And this has been in place for as long as I can remember, and it's grossly unfair, but there we are. In that case, the sort of costs you're looking at are a matter of a few £100s, so far as we are concerned, to do the pre-action work. Once you reach the stage of issuing proceedings, then we apply for legal aid in the name of the child, because it is the child's claim, and that is assessed, as I say, on the child's finances. Usually that means it's straightforward. They get legal aid and it's on legal aid from there on. Yes, we do legal aid work in judicial review cases. That is different from education work for tribunal appeals.
Can I just share on a couple of points on legal aid? The legal aid pre-action work, if the parents are financially eligible, may be entitled to legal aid. If not, if parents are not financially eligible, then the pre-action work, I'm afraid, is on a private basis. But once it comes to issuing proceedings, the legal aid can be assessed in the name or can be in the name of the child, unless the child's got a trust fund or has access to or income, etc. Going back to pre-action work, and Keith talked about the house, there has recently been a case about capital being taken into account. And if you, because it is madness, frankly, that the equity in your house should be taken into account, because when assessing, let us say, a parent for eligibility to legal aid, there are 3 steps, really. 1, merits of the case. Well, if a local authority is not doing what they should do, your merits are done. So you tick that box. 2, income. If a parent is on either a low income or a passported benefit, they will be eligible. Unfortunately, the legal aid agency's view of what a low income is and what others might consider the threshold for a low income are somewhat different. When assessing income, things such as mortgage payments per month and rental payments per month are taken into account. But everyday expenses such as council tax, electricity, gas, etc., are not taken into account. But you might be eligible on income there.
Okay, so we have a couple of follow-up questions.
Hang on a second, capital. If I just go into capital, what Keith said about capital and equity, the equity in your house may be taken into account, but following a recent case a couple of weeks ago, the legal aid agency now have discretion. So it may be that, and the equity in the house has to be over a certain limit anyway. So if you're thinking about asking for legal aid or pre-action work and you have equity in your house, just I think my suggestion would be ring the office and a quick check can be done. Sorry, Emma, next question.
No, so there's 2 further follow-up questions to that. So one is asked, so if the house is worth over 200k, does that mean a child cannot get legal aid for their part? And
no, stop there, let me answer that. If the house is worth 200k, doesn't affect the child because the child won't have an interest in that property. Remember what Keith and I said about there's two parts to judicial review. One is your pre-action letter and are you eligible for legal aid? And the criteria for eligibility there is different. It is very much pre-action work. It's the income and capital of the parents. But also if a house is worth 200,000, the mortgage is taken into account. So the mortgage is deducted and also there is now discretion with the legal aid agency. Given that we're talking about the rights of a child or young person with special needs, I would hope that discretion would be used. But it's the net value of the house that's taken into account for pre-action work. Next part of the question.
Can I come in on that one, Beverly?
Yeah.
In fact, the discretion to be exercised if someone asks me to assist them as a parent in pre-action work and it appears that their house takes them over the limit, that discretionary decision is for me to take because this is legal help work. It doesn't go to the legal aid agency. We make that decision. And I'll be very interested to hear from people who do need this sort of help, who might otherwise be frustrated in getting legal aid because of the value of their house. So you can email me through the firm and I would assist.
That's
so
very
cool. So the second half of the question is just reiterating, is the 200k equity in the house or the value of the house?
It's the equity which the legal aid agency take into account, not the value.
Okay, so I think we've now covered all the questions that I currently have about legal aid and how to get it. The next one is please could you just clarify what should be in section D, social care, and who writes it and when it gets reviewed? Thanks.
So social care also should be reviewed at an annual review. You should have a social care assessment. they're often pretty hopeless social care assessments for EHCPs, and that's because I think that social care, certainly in the last year, have been extremely busy with childcare work and children who are vulnerable and at risk, and have neglected this important area, in my view. But also, they don't quite, I think social care don't quite know what they should be writing. So I have had seen reports written for an annual review or for an EHCP, which from social care, which don't detail what the needs are of that child and don't detail what provision could be made for that child. For example, if you have a teenager or is struggling to needs opportunities for socializing, would benefit from some horse riding for the disabled, or having a mentor to take him to a local youth club, or some specialist, let's just say there's a swimming session for those with whatever difficulty your child or young person's got once a week, and it would be helpful to have somebody take that child or young person there. Or for example, if your child has significant needs, and you as parents could do with at least one night a week respite, that can all be in social care. So what you can do is ask for a needs assessment, and then whatever, as I say, the actual assessments are very poor at the minute, and it is something I think that does need some work on in some ways. The assessments are poor because I've seen some assessments that deal more with the risk. So they're meant to be assessing what the needs of the child are and what provision could be made by social care to deal with those particular needs. But sometimes they say, oh, you know, there is no, they look at the parent, they look at the wrong things. And so I think some social care departments have not quite got the hang of what they're meant to be doing. If you want an assessment, then ask for one. Definitely ask for one if you're sort of part of the HC process. If you're going to an annual review, ask for one early on, because social care assessments will take some time. But you can ask for almost anything, you know, if there is something that would assist your child or young person in meeting the outcomes in the HCP by having provision made by social care outside of the school day, then you can ask social care to fund that. Next question.
So very similar to social care, but how does it work in, for instance, say you haven't had health advice and information for years and there's been nothing really from health? What would you potentially be looking for in regards to health in terms of any annual review or amending the EHC plans?
Well, I would ask for up-to-date reports, up-to-date assessments from health. It depends what the health issue is, and does it affect. You want details and up-to-date knowledge of what the health issues are for your child or young person. It's not often that health make provision, not to say they don't, but it would be, if your child has or young person has health issues, then it's likely to be a benefit to have that in the EHCP, and have that, because if your child or young person has a health issue which is deteriorating or improving, then you would want up-to-date information for the annual review. You don't, if your child has a health issue which is pretty static, then you would not necessarily want an up-to-date health report every year. But if your child or young person has a health condition which is changing, or either improving or getting worse, then you may want up-to-date input from an up-to-date assessments and reports from a health professional. So if your child or young person, for example, has seizures, you probably would want up-to-date reports and assessments saying, you know, are those seizures increasing, decreasing? What medication is this child or young person on? What is being proposed in the future? If your child or young person has a significant vision impairment, for example, then you probably would want an assessment of their vision every year. because that is so it does depend on what the health issues are. I certainly, if you as a parent feel that you want an up-to-date assessment and report from a health professional in respect of a condition which your child or young person has, then do ask the local authority for to ask them to ensure that health provide that report. One of the problems with the EHC process at the moment is that if you were to appeal against the contents of the EHCP, if I put it this way, the other side to those proceedings is the local authority. And although under the National Trial Scheme, you can appeal against health and social care, health and social care are not usually joined, well, they're not joined as a party. So health and social care sort of throw their hands up almost and say, oh, nothing to do with us. So the local authority has a difficult job because they have to twist the arm of health and social care if they're not being helpful and complying, to ensure that they provide up-to-date information, assessments and reports for tribunals. So if you appeal against sections B and F to a tribunal, you may also wish to appeal under the national trial against parts of health and social care. Tribunal cannot order health and social care to do anything, but they can make recommendations, and they do so. And if a local authority or health did not comply with the recommendations of a tribunal, that is likely to be viewed as unreasonable and could be subject to judicial review. But to my knowledge, most health, social care, local authorities, where a tribunal has made recommendations in respect of health or social care, the tribunal, the health and social care have always complied with those recommendations. So it's not an order in the same way as a tribunal makes orders about BF and I, but they make recommendations about health and social care. And that could be that there is a full and it might be that there is a full and up-to-date assessment by health of your child or young person. So that might be one way of getting it. But if you're not at the tribunal stage, then I would be putting pressure on the local authority to request that from the health.
Okay, so the next question is a slightly more complex one. So the child is moving school to a different local authority, but they remain living in the original local authority. Would that force a review? So basically, because the child is being educated in an out-of-school placement, the local authority is saying that it would force an annual review.
Well, if your child or young person is moving, well, I would just read the question again, because
so the child isn't moving where their family home is.
That doesn't matter, which is fine. That's fine.
They are just being educated outside of the local authority. Would that force a review?
No, I can't. Well, I can't see that it does, on the basis that I presume there has been an annual review, or there has been a review that has then named this out-of-county placement. Being educated, I mean, it sounds as though the local authority have agreed to this out-of-county placement and have agreed to amend the HCP to name the out-of-county placement. So I'm not sure why you would need another annual review for the out-of-county placement.
And I think can you confirm that when reviews only happen, particularly if you actually move your family home to a different local authority? It's not about where the school moves, it's about where you move.
Yeah, absolutely, Emma, that's correct. It's where you and the family are living. That's the local authority that it has the statutory responsibility for maintaining the HCP and has the statutory responsibility for ensuring that the EHCP is reviewed every year.
Okay, so the next question is, okay, so this is another very complex one. has there been a JR or case law to determine what is reasonable, e.g. at needs assessment, the parent can make a reasonable request. So this is, Keith, this is where we're looking at SEN regulation 61H, where it says a parent, if they deem it reasonable, can request advice from a particular person. This is in particular relation to speech and language, where the need is really clear, but the local authority are refusing to obtain that advice. So Keith, you might want to come on this one.
I certainly don't know of any particular JR on that point, but I would say it's open to JR. I'll leave it to Keith.
Keith, I think we've done at least a couple now whereby it's been a refusal on the counts of reasonability to obtain advice.
Yes, first of all, it's not whether the parent thinks it's reasonable, it's whether the local authority thinks it's reasonable. And the local authority making its decision on whether or not the request is reasonable, it has to take into account everything that is relevant to that decision. So if you have information from a speech and language therapist or from a source that clearly makes it clear that there is a speech and language need, then it would, on the face of it, be unreasonable for the local authority to refuse. But there may be other factors. But certainly, if there is sufficient evidence there to show that this is a reasonable request, then the local authority would be acting unlawfully if it failed to carry that out. And it would be subject to judicial review to challenge it.
Okay, so the next question is, if things are detailed in the reports from professionals, both NHS and private, as helping the child, should it specifically state these should continue and be in the EHC plan? The tribunal didn't put these provisions in, despite 5 professionals stating the benefits. The judge said it should say this should be in the EHC plan.
So that again, so you just
there's provision being provided from both NHS and private as helping the child, and they're wondering whether that should be specifically stated in the EHC plan. I think, to be honest, that one might need support outside of this, because it's a very, very specific issue. So it's about a tribunal. Deeming certain provisions shouldn't be in.
Well, I think that generally, if you've got experts' reports which suggest provision, or provision is being provided, and it may be that there is and there is evidence that that provision is needed, then it ought to be in the HCP. But if you've already had a tribunal, and the tribunal has decided not to put that in the EHCP, you're pretty much limited on what you can do. You can appeal against the tribunal decision on a point of law, but other than that, you're a bit scuppered because you've already got a tribunal decision.
Okay, so the next question is, what is the time frame for making a judicial review from the LA unlawfully carrying out reasonable requests?
As soon as possible is my answer. Keith?
The answer is as soon as possible, and in any event within 3 months of the decision. It's not quite as rigid as that, but the rules are promptly and in any event within 3 months.
So I'll just give you a couple of minutes for any further questions or anything in the chat. And then if we're all done, I'll leave it over to Beverly to close.
Okay, then, well, thank you very much, everybody who's attended. Next week, the recordings from these sessions will be put on our Facebook page, or links on our Facebook page to YouTube, so you can rewatch any of them. I do hope that those attending found it useful. In our experience, annual reviews can be a cause of difficulty because local authorities fail quite often to comply with their statutory obligation. Thank you for joining us. Tomorrow, we will be discussing all things Section F. Thank you. Bye-bye.